Okay, great. So this is Senate Judiciary on Friday, March 29th, which is the last meeting in the month of March. Next meeting will be in April. Keep that in mind, as Monday is, I believe, the first day of April, although we can't see our board because the board fell off the wall and BGS won't fix it. I suppose we should call Jennifer Bitch and tell her how frustrated I am. All right, I will. Is there our first order of business is the confirmation of Kate T. Gallagher as a Superior Court judge for the northwestern area of the North Region of Vermont. That's a new title. I didn't realize we did. So, is there a motion to report favorably or unfavorably? Senator,
I would move that the nomination be reported favorably.
Senator Booth has moved to report the nomination of Kate T. Gallagher as a Superior Court judge favorably. Is there any discussion? We have not heard from any of the members of the public about this, so I'm assuming there's not a concern. So with that, Ben, could you please call roll?
Senator Booth?
Yes.
Senator Norris?
Yes.
Senator Gromowski?
Yes.
Senator Shi?
Yes.
Senator Sears?
Yes. Who would like to report for the northwestern area of the northern region?
It's got Bob Norris, western area of the North Region.
I think that kind of is you, Senator.
I would be more than happy to report.
Thank you.
Confirmation.
Thank you. All right. Our next area of concern is the H645, which is a bill that came over from the other body dealing with community justice centers. And our first witness is Ben Novakowski, our ace draft person who did such a wonderful job on the bail bill yesterday that I was able to explain it without falling too far in my face. I think the only mistake I made was saying I got elected in 1993 when I was actually elected in 1992 and started serving in that. Other than that, it went well, and I forgot to hand out the handout on the firearms that Eric had prepared that I was gonna do, so I got that for third reading.
It's only 59 pages.
This is a big bill.
Didn't you bring a copy to the Secretary of the Senate though to be handed out there? I thought you brought that up there.
Yeah, I did.
We didn't get that though.
You didn't get it because I forgot it yesterday.
Oh, but you gave it to him, we still didn't get it.
No, I gave it to him after we
Okay.
reported the bill,
I still
because I forgot to give it to him. So it'll come out before third reading this morning.
Okay, thanks.
Well, good morning, everybody. For the record, my name is Ben Novograd from the Office of Legislative Counsel. I do have to say, I realize my House bills got punted yesterday, so might be called away sometime this morning on the House floor. I apologize in advance. You know how the House goes. Senator Sears.
I don't even know why we have one, but if we did, it'd be 75 members would be a lot more effective.
You know, there are some states that have unicameral legislatures.
We do have a member of the House, but.
Yeah. I understand that. Well, unicameral or 75, sign with me. I've never been to the Nebraska legislature, but I've been to the Virgin Islands legislature, which is unicameral. They also do zoning and potholes.
The legislature?
Yeah.
Interesting.
Yeah.
The legislators themselves?
No, they don't. Well, I wouldn't be surprised if a few of them don't get out there, but, no, they're in charge of zoning and all the local ordinances for all three islands.
But they're not traveling and filling potholes.
No, they're not doing potholes.
So before the committee this morning is H645, which is.
Yeah, I think we were gonna hear from Kate first, Ben.
Oh,
Karen?
That's okay.
yeah, of course.
Karen.
Representative?
Oh, my God. Well, sorry about that, Karen.
was being called up to the table.
I screwed up then.
No
You would
comment.
think it was me that was in the house until 10 last night.
I heard they were there till 11.
Well, it was 10 before they allowed the ledge council to go,
Ah,
because they weren't gonna get to their bills or something.
Except for Ellen,
gotcha.
and her bill.
Okay, so Karen, good morning and welcome to Senate Judiciary.
Good morning. Karen Dolan, representative from Essex Junction for the record. Thank you so much for taking this look at H645. I was the reporter of the bill in the House, and happy to just give an overview of the journey of this bill. It's really been years in the making, but the goal of it is to expand access to restorative justice across Vermont. I'm guessing folks in this room are very familiar with all the entities that build our restorative justice community in the state. And what we have been doing for the past couple of years is having conversations to really understand how can we build on the strong success that we have of restorative justice and make a system that is, one, sustainable and one that is cost effective. And the timing of this works out great with our current concerns around public safety, with the court backlog, with the judiciary, because opening up our restorative justice system, in particular, this bill creates a pre-charge diversion program, creates a significant off-ramp opportunity for things to avoid our criminal justice system while still holding folks accountable and including more victim voice. So that's the bill in a nutshell. There are some, obviously, or not some, a lot of details in the bill. I will say it's a 60-page bill, but a lot of it is current language. So, but we kept it in there for context. And this journey has been a lot of collaboration, a lot of stakeholder input meetings over the past couple of years. It really came across when we were looking at justice reinvestment funding and kind of saw, oh, that's funding this is funding that. Does this make sense? And how can we make this more stable and more sustainable? So I won't sugarcoat things and say everybody is super psyched about this bill. I think this is at a place where folks are happy with things and can see it moving forward. That, I think, is an indication of change, right? There are some folks, I would say, like the state's attorneys in particular, kind of like, what's the problem you're trying to solve? Things are working just fine for us, but if you peel things back, it's not really working at the statewide level for consistency wise and for funding wise. And so we're trying to create a system that meets all of those marks. So some of the things that we really focused on is trying to meet the needs of all the different types of restorative centers that are out there in the state. And you'll probably hear from witnesses, there's a variety of them. I think we addressed those needs. State's attorneys were very concerned about discretion. That is preserved throughout the bill. It makes it very clear that ultimately state's attorneys hold that the whole entire way. And there is also a question about the expungement of diversion records. Some folks wanted to change that to sealing. We didn't get to that part because folks probably know there's another bill that's coming, 655, that's around sealing, moving things from. So just want to kind of put out the picture a little bit that I feel like this is in a good spot, but you're going to probably hear some things that could be tweaked with it. But the goal of this is to create a new program and start the change process so that we can really expand restorative justice in our state.
Good. Senator Brewer.
Thank you, Representative Dolan. Wondering, you said not everybody's super psyched. And then you said, you mentioned the state's attorneys and said they don't, it sounded like they're just asking, why are we doing this? We don't see a problem. Is there anybody who's more actively opposing any pieces of it?
No, I think we were able to address everybody else's concerns with it. So I should say, like, overwhelmingly, folks are supportive of this bill. I think it is the process that we took in the House to get there. Like, there's part of me that's lingers a little bit because we did have a lot of those hard conversations to land there. I will say, I don't know if you'll hear from state's attorneys that yes, we support, you need to move this through. Again, I think it's because for them, the current system is working. They get to create a pre-charge program that works for them. There's funding that's coming from DOC, but providers can't rely on that funding. They can't rely on consistency of practice. And so the whole foundation of it is not stable. And that's what this bill tries to do, is stabilize that, so that what we're trying to tell states attorneys, so that this program can exist for them for years down the road.
Senator Bowes.
Yeah, thank you, Representative Dolan. One of the things that I often think about when I sort of zoom out of Chittenden County, where we have a lot of restorative justice options, and when I start to look at the whole state, is geographic justice. Does this bill seek to move us in the direction where every person in every county and every town has similar access to restorative justice options?
Yes, it takes us on that path.
Okay.
So the goal was to have a standard pre-charge diversion program across the state. State's attorneys really pushed back on that, of saying, that gets into their discretion. And so what we decided to do is we wanted to have the same program available across all counties. So that is going to be available. The Attorney General's office has stepped up to say, we will take on this pre-charge diversion, which right now there's no kind of oversight like that. Everybody just kind of making up their own programs and doing it. So there'll be a consistent program, but it will only be available in a county if a state's attorney adopts a policy around pre-charge diversion, which you'll see in the bill, there's some components that it has to have. So it's still very open, but the goal is, if we can at least get that established and see transparently what state's attorneys are determining is a pre-charge program, then we can start to compare and see, oh, okay, this is what you want. How can we work with you to create this consistent vision?
Let's see, at the end of the bill in sections 5, 6, 7, 8, there's appropriations that have or funding alternative report. So I'm curious as to how much money was in there, because it all says now to the extent funds are available. And I'm sure your appropriations committee put that language in and not the House Judiciary Committee.
Yes.
What is the goal in terms of additional funding?
So this bill asks for 2 positions. One through the Attorney General's office that would coordinate the pre-charge diversion program, similar to their current diversion program. And then the Department of State's Attorneys and Sheriffs was asking for a position to assist with the policy development of having each state's attorney have a policy.
And is there a fiscal note?
Yes.
Do you have that?
I can pull up.
Yeah, maybe for the next meeting on this, if you could have, if we can go over the fiscal note before the House Appropriations Committee took the money out. Did they put it back in the budget, or did they leave it out?
So what has happened is, know where folks are on the House. We have our House budget that has gone through, but then we also have a access to justice bill that includes funding for a whole bunch of positions and efforts in the judiciary, and it's attached with a revenue specific to that.
This is,
That's
driving us a
rather
little-
strange.
it's driving us a little nuts in appropriations because, especially the chair, because, we're of the opinion that the budget is,
The holder.
yeah, the universal document, and everything should be represented here, but now there's large sums of money traveling in individual bills, which are also tax provisions. So they're not traveling in the tax bill, they're not traveling in the budget. So you've got these little sovereign bills that are floating around, and it's hard to make decisions with the overview of the budget without having those represented there.
I can't make a decision on this bill one way or the other, till I know
Yeah, what it's competing against.
what it's competing against.
Yeah.
We totaled up yesterday the requests in the criminal justice arena, not including this bill, of $30 million over the governor's recommend.
Yeah.
So how do I get, you know, and I know Jane said she's gonna give us a box, our committee a box.
Yeah,
We went over what would be our priorities, but I think our priorities were already 11 million. And I doubt she's gonna give us that much of a box, and then to try to add this into that 11 million, which is the way the Senate would probably do it, which I can tell you, this is a quandary this year that and being on both committees is, I'm struggling with, because I've never seen it like this.
and I don't understand what, you know, because it's maybe got positives, I just can't see what they are to doing it that way.
For the funding piece of it.
Right, and especially creating new revenue drivers specific to that, because then it seems like you're prejudging a whole bunch of decisions, like if this is new revenue, should it go for that? But since it's all packaged together, at some point, you're gonna have to cannibalize the bill and pull it all apart anyway.
Yeah.
So I'm not sure why the decision is being made to advance down that path this session, but.
And that is a piece I feel like I'm probably not prepared to speak to
Yeah,
at that level of it. I will say, one of the other things with this bill is because these pre-charge referrals are happening already in our state, but in a very unorganized way. Like there's funding that's going to it right now, but the majority of the funding is coming from DOC, which that is not DOC's population area, is pre-charge folks. And so this is what creates this confusion that has been happening. Is DOC is providing the funding, not necessarily a lot of the oversight and guidance of how to do these pre-charge things. And so we're trying to clean it up.
Yeah, understood. I understand there's a lot of, you know, these programs started in many cases 30, 40 years ago, when restorative justice became a popular tool, and particularly for minor offenses, and it was called diversion, and they cropped up in various communities under various names. And then the Attorney General's office, I believe the history is the Attorney General's office became involved in funding these programs that were really by bootstraps. They had been started locally around the state. So now we're at a point where you're absolutely correct. There's some areas that have very vibrant pre-charge programs. Others, you have to wait till you've been charged in order to get there. And once you've been charged, you've got a public record that needs to be expunged publicly. So anyway, I don't have an opposition to trying to formalize having statewide opportunities for everybody. I mean, it's always been a little bit ridiculous that you could be shoplifting, maybe shoplifting is a bad example because people are so upset about it, but you could knock over a mailbox, you know, and, you know, get a charge in one county and another county be pre-charged, and as long as you pay for the mailbox you knocked over, you're fine. So I think there's a certain unfairness there, but so in that realm, I'm certainly supportive of the idea of organizing. This is, I don't know whether it's the right way, but we really appreciate you coming down here and spending some time with us, and we will give it a thorough review. But as Senator Baruth said, and I think the Senate is pretty much in agreement, that the budgeting process of separate bills on access to justice and who knows what else up there is going to be very confusing for us.
There's the Medicare, Medicaid expansion bill.
Yes.
Yeah.
Yes, and housing is also a separate. And one thing I will just share, it's not ideal, but I would, again, a ton of work has been in this. So even if it can be passed, even potentially without a fund, like it is stepping us in a direction and giving us the framework that we can move forward. So I'm fully supporting the funding. I feel like this is what is needed, and hopefully you'll hear from multiple people, but if we can even just pass this idea and get it started, that's going to be huge for our state.
Okay. But looking at the one other thing about funding, I just need to make everybody clear about. The House added in their budget, I believe, $14 million in new spending, but they only spent 7 million because they started all the new programs January 1st. So in 2026, they're gonna need 14 million. So after they made their cuts in the 30 million that we talked about, they got down to 14 million. Then they funded 7, but now there are other programs that may be out there that I haven't accounted for in other bills, like the access to justice bill. So, but thank you.
Thank you.
And appreciate the work because it's clearly comprehensive.
Yeah, and I'm able to be here till, well, as council goes through it, just in case I can be helpful with questions.
So Ben, if we could take a high view dive,
Yes.
not a deep dive, but a shallow dive, maybe a belly flop.
All right, hopefully we don't hit our head on the bottom of the pool.
Don't do that, it'd be terrible.
So again, Ben Overdrowski from the Office of Legislative Counsel. My thanks to Representative Dolan, who I think gave a really good overview of the process to get to this point. Basically, what this bill does is expand the concept of diversion, which is currently under the auspices of the Attorney General's office. And currently the way that diversion works is that you need to be charged in order to be eligible to participate in the program. What this does is leaves that program unchanged, but adds a pre-charge diversion under the auspices of the Attorney General's office to provide an off-ramp, as Representative Dolan said, before those people are actually in the criminal justice system, so that they can either be referred to the appropriate community providers to get the help that they need, or to repair the harm that they are responsible for with the victims of that harm. So in addition to establishing that program statewide, it also sets in motion certain initiatives to stabilize the funding long-term. As Representative Dolan said, right now the providers are funded by the Department of Corrections through a grant system. That provides a lot of instability for those providers because year to year, they don't know how much their grant is going to be. And there was a lot of testimony in the House.
But isn't there also funding from the Attorney General's office and the DCF?
So, yes, it's a kind of a spaghetti map of funding, to be quite honest. So there, and I can provide, there is, I should have provided this ahead of time, but I can send it to Ben, sort of an outline of what this funding structure is,
Okay.
who DCF funds, who DOC funds, and who the AGs.
I know there's currently a disagreement amongst the providers and the Department of Corrections over around 900,000. Is that base or is it one-time money?
Right.
So the Department of Corrections is saying, we didn't cut, we have a 2 million something base.
Mm-hmm.
We're providing that, we didn't cut that. But then there was 900,000, I believe, from Justice Reinvestment.
Right.
That the providers saw as a ongoing funding.
Mm-hmm.
And the corrections department says, no, that wasn't ongoing, that was one-time funding.
Right.
So there's no guarantee you'll get that 900,000.
Precisely.
That's a real mess. And then you've got DCF and the Attorney General's office providing additional funding.
Right. Yeah, and the way it's done is that, DCF is all contract based. There's actually no statute saying you need to support X, Y, and Z program. DOC has the Community Justice Center statutes that funds, but Community Justice Center is sort of a misnomer. They think that a lot of people think it's a one-stop shop. You go into Community Justice Center, you have diversion, you have DLS, you have youth substance abuse training. It's not as clean cut as that. A lot of times through the funding structures, they're in different locations. And so thinking of it as a center is sometimes not exactly correct.
So the main thing this bill does is create pre-charge throughout the state.
It does, and then it sets some initiatives in motion to assess a more stable funding structure over time. So what it does is that it will shift pre-charge funding to the Attorney General, leave post-charge with DOC for the time being, and then the Attorney General's office has to do a study over the next couple of years about a more stable funding structure, and then they need to report to the legislature in 2027 And so there could be some, action taken based on the findings of that report about how better to stabilize the funding for all providers. So that, and there's also a study, for a post-adjudication reparative program or a working group so that people can be referred to providers after they've been convicted. And so there's multiple components to this. Establishing pre-charge to keep people out of the system, but for people that are in the system that are formally charged, there's also some reparative work that can be ordered by the court, or that's the thinking at least, if they are sentenced to reparative boards or to probation. But right now, that's a working group to study what that program could look
May
like.
I suggest that as we progress with this bill, that you could work with the Joint Fiscal Office, and we include in sustainable funding, number one, the community justice centers and the diversion programs throughout the state. And number two, the network against domestic violence and sexual assault programs, because they're relying on special funds that are not coming in. And they both need, and I don't think we can wait until 27 to solve this problem. This is really an emergent problem.
Does crime victim
We,
services
we,
have that?
we funded the network with marriage license fees, but the finance committee, I believe, put a sunset of next July on it. But I think it was next July. So I would like the date to reflect July 1 of 2026 and not 27. And we add the network programs to the stability.
I was just wondering, my memory's a little hazy, was crime victim services also suffering the revenue
Yeah.
loss? Should we add them?
Yeah, probably.
Yeah.
But theirs is because of the violence against women's grants.
Yeah,
It's not due to,
but I remember
funding.
when we.
Yeah, it's not due to our, but it's the same. You're absolutely correct. It's a similar problem. But theirs is because of the federal grants have dried up,
Yeah.
as Jennifer testified.
I appreciate you putting that in, because these things are all so linked, and I think if we're not adequately making sure we're covering all of these things, we're doing a disservice to every one of the programs.
Yeah.
Anyway,
So to keep it high level, but to get more into the specifics. So what this bill does is that it creates a pre-charge diversion program for juveniles and for adults. It defines what pre-charge diversion is, which is a referral of an individual to community-based restorative justice provider by a law enforcement officer or a prosecutor after the referring officer or prosecutor has determined that probable cause exists, that the individual has committed a criminal offense, and before the individual is criminally charged with the offense, or before a petition is filed in family court for the offense. So basically, it defines it as before a judge makes a finding of probable cause at an arraignment, but the prosecutor or the law enforcement officer thinks there's enough evidence to support probable cause, which is essentially how it works right now. A probable cause affidavit is filled out by a law enforcement officer, or they consult with the prosecutor on an incident. And they can make a determination about, does this rise to the level of probable cause? So that's what this definition attempts to capture. And so section 1, and you'll see here, this also is a large reorganization of the Attorney General statute. So that's why there are a lot more cross-outs and things. The bill appears a little bit bigger than it truly is. And then it also creates a pre-charged diversion program for adults, and they're largely the same, but there are a few key differences. Specifically for adults, those that have been referred to Tamarack, their cases don't become confidential until they've completed the diversion program. And there are some small changes to the post-charge expungement process, but other than that, they're mostly identical. So I think going through the juvenile diversion program will give the committee enough of a sense of what the program does, and I'll refrain from going into the adult program as well in an effort of
who
time.
gives the law enforcement officer authority to refer a person to a pre-charge diversion program?
Who gets
Under the
these?
bill? Who gives? I understand the prosecutor can do it, but it says on line 14, page 1, a by a law enforcement officer or prosecutor after referring officer or prosecutor to determine probable cause exists. Well, who gives so a police officer on the street can actually refer somebody?
Yes, and currently the way it's
Who
done
gives
is,
them that authority, the prosecutor or the?
well, they currently have the authority. I mean, it's currently being done. It's really done through the agreement with the prosecutor of the county. And what this will attempt to do is that what this mandates is that every prosecutor throughout the state, so all 14 prosecutors must adopt a model policy in order for their providers to receive funding. If they don't do that, it's not going to work. And so if they have this agreement in place, if they have this model policy in place in which they can determine which offenses are eligible for referral, that would presumably be done in consultation with the local law enforcement so that there's an agreement there and that these model policies are publicly posted on the Attorney General's office so that there is transparency about which offenses in each county. And to go to the geographic equity issue, this is, it mitigates true equity because, and this was one of the compromises that was made in the House about prosecutorial discretion, which is a constitutional right that prosecutors have about when and whom to charge. So rather than creating a potential constitutional issue with the legislature mandating on prosecutors how to exercise their discretion, the only mandate is to adopt a policy itself, and they retain the discretion to put in whatever they want into that policy.
Then, and who knows if this is even a realistic possibility, but if I understood you right, what if a state's attorney does not adopt the policy, says they're not going to, the consequences fall on their providers, right?
Yes.
And what then? Suppose they continue to insist they're not going to adopt. Let's say they had a thing against pre-charge diversion. They just didn't agree with it. They didn't want to do it. Would we be then, in effect, cutting off the funding to their providers indefinitely?
Until they adopt a policy, and that would be a decision that they have the discretion to make.
Okay.
Yeah.
My concern is, I think, in line with Senator Bruce's concern, and that is if you see, so I'm assuming, and I don't want you to speak for the state's attorneys, that state's attorneys and counties that are already doing this have a policy, but if they don't, would this effectively mean that they can no longer do pre-charge in their county?
Not that they can't do it, but for their providers to receive grants or contracts.
So they can do it for free.
Right.
So the providers get punished if the state's attorney doesn't develop a policy?
Yes.
Maybe Representative.
May I clarify one thing? Is could we leave this switch at the end so that entities can still get funding?
Right.
They can't start making referrals until the state's attorney has a policy. Because what's happening right now is there are some pre-charge programs that don't have policies. So what we're saying is we want to support this pre-charge program. If you're going to do it, and we're going to provide you with supported providers, let's see your policy of what you're going to do. So that's what we're saying is you need to have a policy in order for the centers to start accepting referrals.
Thank you. So, Ben, if you want to continue.
Sure. And so, I mean, I can go page by page, but I'm kind of summarizing it.
No, I think it's better to summarize it
Okay.
first, and then if there's questions, we can go to the page.
So this program, again, and if you look at for the juvenile, it's just, and this is the same for the adult, to provide restorative options for children and youth who have caused harm. The juvenile diversion program can accept referrals, can accept pre-charge referrals through law enforcement or prosecutors pursuant to that policy, or post-charge by prosecutors for a first or second misdemeanor or first violent felony or other offenses as the prosecutor deems appropriate. And that is current law, essentially, with the exception of that addition at the end, other offenses as the prosecutor deems appropriate. This also establishes the administration of the program by the Attorney General, as we've established. That would start on July 1st of 2025, and that the Attorney General supports the operation of the program through grants or contracts with a single municipality or organization to provide community-based programs in a specific county. The Attorney General can then approve that municipality or that organization to then issue sub-grants or contracts with other providers in that county. This also has a data collection component to it as well, that the Office of Attorney General shall develop program outcomes in consultation with the community-based restorative justice providers and other stakeholders, and shall report to the legislature on December 1st of each year on the services provided and the outcomes of those services. As part of that report, there's a slew of demographic data, the number of pre-charge and post-charge referrals in each county, race, gender, age, and other demographic variables whenever they're available, the types of offenses charged and the crime types, success rates, and possible causes of any geographical disparities. That's something that does not currently exist, this type of data collection, at least on the pre-charge side. It's something that exists on the post-charge side, maybe not to this level of degree, so that's another initiative in this bill. There is a policies and procedures manual that the Attorney General must establish to help prosecutors and community-based providers administer the program. That includes informing victims of their rights, timely notifications of victims of these referrals, an invitation to the victims to engage in the process, because that is a key component of the restorative process. Also outlining how to share information with victims. There are certain confidentiality procedures that need to be adhered to, and then best practices for data collection and confidentiality expectations, I said. So this manual is mandated here, and then the substantive laws supporting the manuals later on in the bill. And what you'll see is that for a county's community-based restorative justice provider to be eligible to receive these referrals, the state's attorney must adopt this policy. The policy must contain certain things, a list of offenses that presumptively qualify.
Okay, I'm gonna stop you right there.
Yes.
What I've learned in my 40 years of working with troubled youth, the nature of the crime does not indicate the problem it has. And using the nature of the crime as your determinant for referral to a pre-charge diversion program is just the opposite from all of what we've learned over the 100 years. And I can tell you that that's why a delinquent act is a delinquent act, whether it's murder or whether it's shoplifting a candy bar. The crime has nothing to do with it. So I think this is absolutely the wrong way to go, personally. Senate, you just let me.
Yeah.
And it's not your fault. I'm just saying that I'm going to put my foot down here, that if we're gonna use charging and the nature of the criminal act, we're gonna miss an awful lot of kids with some extreme problems. And we're gonna have some kids with no problems at all that screwed up and are not eligible for recharge. I think this is really a backwards way to go based on all the science and everything that I've learned in 40 years of work in trouble.
Well, Senator Sears, maybe I misspoke.
No, I'm reading page 7, and it's exactly what it says. The policies show a list of offenses that presumptively qualify for juvenile-free diversion. So once you list the offenses, you are doing something, in my mind, that doesn't reflect the severity of the problems that kid faces. And I will, until I'm blue in the face, this is not something that I could ever vote for. It's the wrong tool.
And I understand what you're
And
saying.
it's not your fault. You're the drafter.
No, I appreciate that, but it's not just, so I think a good way to think of it is that there are offenses that qualify, and then there's eligibility of individuals, and they're both included in this policy.
Well,
So there'll
maybe
be.
I should have read further, but I gotta tell you that starting out with the offenses is the wrong way to go. We should have the ability to put kids into the appropriate program, whatever that might be, and it may be pre-charge. It may be a residential program, and it could be a candy bar that was stolen.
I think and correct me if I'm wrong, Ben, I think what Ben's trying to say is the intent is to capture both. And so B, any additional criteria to determine whether a child or youth is eligible. I think that's speaking to your concern, Senator Sears. And maybe it's just the fact that one is A and B that makes it seem that it's preferred, but I look to them as equal ways to get into the program.
Yeah, I think that's a correct assessment, is that, and this is part of that, the transparency is that these are gonna be publicly posted. So that way it puts the community on notice, if you will, that, well, if you commit, just hypothetically, retail theft, because that seems to be a hot topic these days, that retail theft might be one of those presumptively qualifying offenses. But then the individual is assessed as well, that maybe, because ultimately, and you'll see, the state's attorney has final discretion over how to create this policy.
But once you've said that retail theft is eligible, then why didn't my Johnny get to diversion and that Johnny did?
Well, I think that kind of speaks to some of the compromise that was made in the bill.
Yeah, I appreciate that.
Yeah.
Senator Bowes.
I was simply going to agree, that I think that once we make a list, particularly for juveniles, given all of the evidence, we are going to leave people out who would absolutely benefit from pretrial services, because, you know, as Senator Sears pointed to, what we know from the data is the severity of the crime, particularly with juveniles, is not predictive of their.
And I just want to emphasize that this is not meant to restrict. If anything, it expands, because the list of offenses, again, just says these offenses, but then there's an assessment of individual eligibility based on certain criteria, which could be a slew of factors. Which gets to, I think, the indicators that you and Senator Sears are speaking to. But I can go forward and.
No, let's go forward.
Yeah. Some of the.
I think Senator Vowski and I identified a problem area for us. And maybe witnesses will help us deal with it.
Yeah. One of the other
But
requirements.
each state's attorney sets their own bills. I mean, their own.
Correct.
Their own, so state's attorney in Chittenden County could be completely different from Windham County in terms of what charge, what offenses are eligible.
That's true.
Okay.
Another requirement of the policy is the appropriate documentation. There was a lot of testimony from various state's attorneys that some state's attorneys don't want to have to produce any. They just want to have a phone call. Some people want a probable cause affidavit, or something in between. So what this does is that they can establish the type of documentation that they want, including the name and contact information of the person, the name and contact information of the victims, and a factual statement or affidavit of probable cause of the alleged incident. So that's what would be included with the referral. They also need to include a procedure for returning a case to the law enforcement agency or the prosecutor, either when the prosecutor withdraws any juvenile pre-charge from the diversion program, or a community-based restorative justice provider determines that the matter is not appropriate for pre-charge programming, and when a child or youth does not successfully complete the pre-charge program. So that's something where their referral can be kicked back to either law enforcement or the prosecutor for either further investigation or for charging or submitting a petition in family court. There also needs to include a statement reiterating the state's attorney's discretion, and that discretion may lead to a deviation from the adopted policy. Again, that was to really bootstrap the prosecutorial discretion that was a hot topic in the House. There are also juvenile diversion program requirements. They need to develop clear criteria for which types of offenses and offenders will be eligible for diversion But again, the prosecutor retains final discretion. And all diversion programs receiving assistance from the Attorney General must adhere to various requirements. They shall only accept individuals against whom a petition has been filed. And, so now we're in post-charge, excuse me. And so we're now in the post-charge juvenile.
Post-charge starts on page
Eight.
9.
8 on 9, and post-charge
Okay.
is largely unchanged from the current diversion statute, so I can skip over that if you'd like.
What is C on page 9?
C, so this is if they've, been referred to, like a Tamarack program. And there was a change here on building out what the ends of justice determination is. So if someone is charged with a qualifying crime and the crime is a misdemeanor, they must provide the opportunity to participate unless the prosecutor states on the record at the preliminary hearing or subsequent hearing why referral would not serve the ends of justice. This is something that was put in years ago, I think, at the behest of Bobby Sands. And this builds out that ends of justice determination as to what it is exactly. So factors that can be included would be their delinquency record, views of the alleged victim or victims, and the need for probationary supervision.
So if the crime is a misdemeanor and the person's not being diverted, the prosecutor puts on the record why they're not diverted.
Correct.
And you say that's current law?
With the exception of building out the ends of justice,
How is ends of justice defined? We usually,
well, it wasn't defined before, and so lines 12 through 14 is an attempt to provide some direction to the court about what it should consider in that determination. And that's a new addition.
okay, but currently they have to do this, they have to file.
Correct.
If they're not. Okay, thank you.
And then there is a small change to the expungement process. Currently, under the law, so if we turn to, actually, I'm gonna hold off on that. I apologize. We're not quite there yet. So there's also, the addition of rights and responsibilities.
Which
that-
page are we on that?
So starting on, I mean, it's technically listed on the bottom of page 11, but really starts on page 12. So these are the rights and responsibilities inherent to both participants or candidates and victims. So one, the court diversion program shall be set up to respect the rights of participants. That's current law. What's new though, is that, well, diversion candidates shall also be informed of their right to the advice, assistance, and access to private counsel at all stages, including the initial decision to participate, so that they may give informed consent. That's current law as well. However, what is new is subsection B on page 13, which provides the opportunity to have free legal assistance to someone in pre-charge diversion. And so it's notwithstanding their financial need, but basically what it does is that it provides a mandate on the diversion program to inform the candidate that they have access to a public defender if they so request. And that is a new addition. And then the candidate shall be informed that participation is voluntary. Turning on to page 14, any victims shall be notified of their rights and role in the pre-charge diversion process, including notification of a candidate's referral to the program by the pre-charge diversion program. So those are the rights and responsibilities attendant to the program. Now we're getting into records, deletion, and expungement. Expungement is the current process for the diversion program now, or post-charge as it's being called now, or called in this bill. Deletion is the same thing as expungement, just for those who are pre-charged, because there is no court process to actually expunge the record. And you'll see here that in the pre-charge realm, not later than 10 days after successful completion of the diversion programming, the juvenile diversion program notifies the victim, law enforcement agency, and state's attorney of the participant's successful completion. Restitution payment is required for that. Within 30 days after the 2-year anniversary that notifies the state's attorney of that successful completion, the Attorney General shall provide a certified notice that all records held by the program be deleted.
So that sentence ends in a way I wasn't expecting. So I thought it was gonna say shall provide a certified notice that all records had been deleted.
Well, so this mirrors sort of the current expungement process
Yeah.
where there's that, basically because I think it gives them a 2-year period to make sure that there wasn't another foul up for lack of a better term. And so what this does is attempt to mirror it. And rather than the court providing a notice to these people, it's the attorney general, since they're sort of the keepers of what you'll see as the special index and all of that. And then, but that deletes programs within the diversion or records within the diversion program. You'll also see in subsection C, similar language that is sent to the law enforcement agency, notice sending to the law enforcement agency and state's attorney, that all public records held by those agencies are deleted. And this does not include Valcor or other similar non-public law enforcement database. That was put in based on testimony by the state's attorneys and law enforcement agencies that they'll need those records for some investigatory purpose later. So that was an attempt to accommodate that.
And if I could just ask, so we've had a long-running disagreement about how to create a single track, sealing, expungement, et cetera. Several bills crashed and burned on the way there. In my way of thinking, because law enforcement and the administration writ large have been seeking not an equivalent kind of sealing to expungement where you would need a court order to go in, but they were seeking sealing that would allow anybody to go in, an arresting officer by the roadside, state's attorneys, DCF, which we balked at in this committee because having put expungement into law, replacing it with something that was so porous in terms of sealing just didn't make sense. So I'm wondering, on the road to this, which is, if I'm reading it right, a 2-year stay on deletion, and then deletion occurs. There's within 30 days, they get a notice that it shall be deleted, and then they're supposed to delete. Was there testimony from law enforcement, state's attorneys, et cetera, that they didn't want deletion? Because that would be consistent with their other arguments about expungement and sealing.
Yeah, I mean, I would say that they were opposed to the initial way that this was drafted, which was you need to delete everything.
Yeah.
So this was an accommodation about
2 years.
Not that just the 2 years, but that they could preserve non-public information on
Let's flag that for concern. But at the same time, Ben, could you look up what we do currently? If you receive youthful offender status, it's like a deferred sentence. And if you successfully complete your youthful offender program, my understanding is your records are expunged, and that includes everything. And I don't want to start us down a track where we're starting to give this information out when we've already expunged it for people, and we've given them that assurance. We've also given, I think, juveniles assurance that their records are sealed, and then we find out they're not as sealed as we thought they were. And I'm getting more and more concerned about this issue. I'm glad that Senator Booth has flagged it, because it's important as we talk about when we get to the sealing bill as well. I know there's some access to the sealed records, but I want to make sure that what's expunged through either youthful offender status or a deferred sentence given by the court, and this person successfully completed that their records are not available. And I think if we're saying to some kid, are we still in the juvenile? We're saying to a kid, you know, yes, you did this, we're giving you diversion, and your record is no longer exists, except that, you know, 20 years later, somebody stops you on the side of the road, they'll be able to access the record that you shoplifted a Milky Way bar. But they won't know what you did. they'll just have some larceny or something there.
Mhm.
So automatically, you put that person in a different category.
I can get that.
When their only problem is they got caught shoplifting that Milky Way bar and I didn't.
I would certainly support moving towards a full expungement. I think the more complex a system is, the harder it is for people to understand. And when we say to someone, this is expunged, except for these instances, 20 years down the road, it's pretty tough for them to remember, well, which instances does someone know what I did and which ones don't they know? And I think it breeds mistrust too, because if we say to someone, it's expunged, and then they learn 20 years down the road, well, actually, it wasn't really expunged, there is a frustration with, well, they lied to me.
Yeah.
And I think it creates mistrust within the system, so I would certainly support moving back towards full expungement.
If we're gonna do a bill, we need to, I understand that there were compromises made in the House on both bills, and I respect that, but we can hear that. But on diversion, I would have thought that, I always thought it was kind of a given that things were no longer available.
Yeah, I mean, if
Because you've
you,
never been convicted of the crime
or charged.
or charged.
So-
Pre-charge, yeah, I think some of this is now we've got post-charge. So
But-
you've been charged, but you've never been convicted of the crime.
But it seems contrary to the whole project to have these records follow someone around.
Right, Senator Sheen.
On the conversation of the effect of deletion, so it's all records, correct? Every document or narrative that's attached to the case is deleted, right?
Yeah, it would be as if it never occurred.
So if there is an instance of prosecutorial misconduct or law enforcement misconduct that can be pieced together through these reports, but they no longer exist, and then several years later, the defendant realizes that they were a victim of misconduct either by a prosecutor or law enforcement, there's nothing for them to refer back to.
Well, I think, I'm trying to recall the testimony from the state's attorney, so don't quote me exactly, is that I think that was one of the reasons that was provided by them as to why they wanted to preserve the non-public records. So if I recall correctly, my colleague Tim Leaders-Dumont, I believe, testified that what if there was an accusation of a Brady violation or something like that, which is you have to disclose exculpatory evidence during discovery. That would be something that would be, in your instance or example, that would be really difficult to dig up if these non-public records were completely deleted. So my understanding is that was one of the reasons that was provided, is to preserve Brady obligations and compliance with those.
The question is who has access to the non-public records?
I'll get to that.
Is it any police officer on the street, or is it, through a court order?
Yeah, I mean, I do know that
There's a difference there. If through a court order, the court releases records for some reason, and then you've been through a process.
so there is a public records exemption and exceptions to that exemption. But under this, it's not really outlined from a law enforcement perspective, but you would need a legitimate law enforcement purpose to access these databases.
Understood.
Yeah.
Let's move on, because we've got about 10 minutes before the break.
There's also a pre-charge diversion case index. This is similar to what's already done. Basically that the Attorney General's office keeps this index about which cases that have been deleted, but with sort of basic information that's kept just to keep record of it. The name of the participant, their date of birth, case number, date of closure, location of programming, and the offense that was the subject of deletion. They're separately held and segregated and confidential. Inspection of the notice may be permitted only upon request by the person who is the subject of the case. And they may, the Attorney General may permit special access for research purposes as well. And then they must establish policies to implement this subsection. And then the effective deletion is, like I said before, as if the matter had never occurred. All references are deleted. The participant, community justice center, law enforcement officer, and departments, prosecutors, referring entity, diversion program shall reply to any request for information that no request actually exists. And then copies of the deletion notice shall be sent to those entities as well. And this will only apply to those people who've completed pre-charge diversion on and after July 1st, which is the effective date of the program.
So I'm just wondering, I don't really understand the purpose of this special index. I mean, it seems like the only person who's allowed to inspect it is the subject of the case. This is the person who is in the program. So it seems that they would know, that they were in the program. No one else can, except the Attorney General may permit special access for research purposes. And I remember that from our discussions with expungement versus sealing. But I don't understand why, if law enforcement can't get it, a judge can't get it, the Attorney General can't use it, why are we keeping it?
Well, a personal anecdote is that whenever you apply to law school, you have to disclose any, criminal history that you may have. One thing that I had to produce is that I had no criminal history. So that would be, this provision would help achieve that result in that situation.
I don't understand how, because.
Well, by saying that no records exist.
No, but it's deleted.
Right.
So the person says no when they apply to law school. They don't have to prove that they don't have a charge. They would only have to show documentation if they were saying they did have a charge, but for this reason.
Right. Oh, and so you're saying, why would that basic information be held within the special
I can
index?
see no purpose.
I might defer to my colleague on the Attorney General's office.
There is a hand in the back, Mr. Chair.
Yes, Senator Will.
Willa Farrell, Attorney General's Office. I can speak to the current practice as relates to post-charge. We have expungement records, and we, not infrequently, actually yesterday I got a request with a signed release for, do you have documentation that I completed diversion successfully? And not only might people volunteer that, there is the internet, and there's often information out there that somebody, it's not necessarily a law enforcement or system record, but there are other ways that people sometimes know that there was law enforcement involvement. And so people seek requests from us. Can you document that I did complete, that I completed diversion successfully? So that's what we provide.
But, and I don't know very much about this, so I'll just ask. When they complete diversion, they must receive some notification that they've completed diversion.
They do, and they may not retain it.
Right, but should we have a special index in perpetuity because somebody might not retain a record? It seems to me, and this is my concern, we're saying that we're deleting it, but we're in fact keeping a state database that includes all the basic information. And since it's not actually deleted, this is my gripe with sealing versus expungement. Since it's not actually gone, any future legislature could, with a stroke of a pen, they could say, oh, this database is going to be available now. And then that person hasn't exactly been lied to, because the authorities at the moment were sincere that it was going to be deleted. But then this database later the decision is made to make it accessible to law enforcement or whatever. So when we say expungement, we mean it's gone forever. In my mind, when we say deletion, it should be deleted, but then to say, we're gonna keep a database in perpetuity anyway, it's not deleted, it's in effect sealed.
It's not available for public review.
Sealed rather than.
Right, but.
Yeah.
But this senator is changed.
And this does mirror the current expungement process too.
Well,
Except it's just not through a court.
yeah.
This might be an outlandish idea, but instead of a case index, why can't the defendant just be given their stack of paperwork and say, here you go, do with it what you want? And in the event that a year or two later, they realize there's a stack of evidence here that shows my defense counsel provided inadequate counsel, and I want to redress that, I can raise it back up. Is that the realm of possibility?
I think that's a policy consideration. I could foresee some potential confidentiality issues when it comes to victim issues that might, or statements that might be contained in that case file. But that's policy consideration, so. Shall I continue?
Please.
You'll see in subsection 5, this is just post-charge diversion records expungement. This is current law with the exception of, you'll see there's A, B, and C. There used to be another factor, which was in order for the court to expunge the records, it had to, the participant had to achieve rehabilitation to the satisfaction of the court. And that was, there was testimony that was a really subjective factor. And questioning how the court could really make such an assessment at just a one-time hearing. So it was suggested that that was removed, and so it was in this bill. And then you'll see expungement of sealed records, that's holdover from current law. So the rest here is still current law because it's the post-charge diversion, which under current law is just called diversion at the moment, but it's just being retermed. And it all continues on to page 19. And on page 20, we have a Public Records Act exemption. So except as otherwise provided, any records or information are exempt from public inspection or copying under the Public Records Act. But notwithstanding subsection 1, law enforcement, state attorney's office, a court, restorative justice provider may disclose information to colleges and other academic institutions in which there are agreements with to use in connection for research purposes. But no person associated with those institutions or agencies shall disclose the information in any manner that would reveal the identity. This has been drafted in other.
That's just research.
Exactly. And then you'll see here, section 164 starts the adult court diversion program, which is largely similar with a couple of changes.
So how long would it take to walk through the rest of the bill?
Well, I will very briefly just give you a summary. So if you go to page, we're going to skip very far forward, to page 44.
That is very fast.
Yeah.
Yeah. So section 2. You'll see that there were confidentiality provisions in the current statute that were just moved to this statute. So you'll see, if you keep flipping forward, outside of some sort of small grammatical and formatting errors, on the bottom of page 48, it says notwithstanding 3 VSA 163A2C, which applies to juveniles, and 164A2C, which applies to adults, the adult or juvenile diversion program shall accept youth substance awareness safety programs pursuant to this section, and the confidentiality provisions of the diversion program shall become effective when a notice of violation is issued. This is essentially just a rewording and a relocation of confidentiality provisions already in the diversion program. That is also the case for section 3 because section 2 regards alcohol, section 3 regards cannabis. So same language in that section as well. You'll see, and that's on the bottom of page 53. Then you'll see section 4 is that restorative justice working group. So this is something that the House Corrections Institutions Committee worked on to create a working group, to create a post-adjudicative reparative program that promotes uniform access to the appropriate community-based service providers for individuals sentenced to reparative boards or probation pursuant to the proper statutes. They shall also study stable and reliable funding structure to support the operation of the appropriate community-based restorative providers that provide those supports to the people who are adjudicated. So that's what section 4 achieves. I can get into the details of that another time. There's sort of a multiple updates that the committee gives or that the working group gives. Section 5 is the creation, to the extent funds are available, of state's attorney.
Right, section. We already.
Yeah, so we did that. Section 7 is the report on essentially a plan to develop and streamline the administration and provision of the pre-charge and post-charge diversion programs that would need to be submitted on or before July 1st of 2027. And it would be included in the report that is already created under the statute. Section 8 provides the Attorney General to grant directly with those other providers in a county, not just a single one in the interim until it goes into effect. So it's really a transitional provision to allow those other providers to receive funding. You'll see section 9 is another report on funding alternatives for community referrals, which would be referrals to community-based restorative justice providers that do not involve criminal offenses for which probable cause has been established, maybe a school incident or something like that.
Truancy.
I'm sorry?
Truancy.
Potentially, but it would be something that doesn't rise to necessarily criminal activity, but one that is a conflict that maybe the police got involved and they thought this should go to some sort of programming.
So state and local funding options, does that include grants, federal grants?
It would not include federal grants.
Shouldn't it?
It could, yeah.
But I know that some community justice, at least our community justice center, I think is funded through town funding too. Some others are,
That could be added.
but I guess that's local.
And then section 10 is just a redesignation of the community justice center statutes from Title 24, which is the municipal laws, to Title 28, which is the corrections laws. It just seems like a more logical placement given who is responsible for funding community justice centers at the moment. And then the effective dates is that the act takes effect on July 1st, 2024, except the pre-charge, the diversion changes and that transitional grant procedure goes into effect on when the program starts on July 1st, 2025.
Okay. Thank you very much for that prompt.
Sorry, it was a little bit longer than
No,
anticipated.
actually,
Yeah.
we held you up, but, you have uncomplicated some things for me. Maybe I, the rest of the committee as well.